So we're going to talk about detention alternatives for the next hour and 40 minutes or so. Commissioner Teresa Powley is going to be one of our first two speakers, Ted Kwasula. You guys each have about 10 to 12 minutes. Are you listening?
Yes. We are, sir. We're
10
listening.
10 to 12 minutes for each of the commissioners. And then Dorothy Alther from California Indian Legal Services, the executive director, and housed in the Escondido office, will have 15 minutes, followed by Matthew Fletcher, 15 minutes to provide your comments. And I'll come up at 10 to 3 and take questions from the audience and try to keep things on track here. So who's going first? Have at it.
We've got Chapter 3 and Chapter 5. We're going to start out on Chapter 3, try to put a little rhyme or reason to this. But as introduced, my name is Ted Kwasula. Mr. Moderator, maybe you ought to yell at those guys out there. I don't want to repeat it. Or answer questions that we already covered. See, that's the way you do it. There you go. No.
And do we have a timekeeper? I know.
All right.
Miss Rockwell.
Just cut into the next panel and give it to it. All right, thank you. Again, we're going to start out with Chapter 3, then end up with Chapter 5. But, 280 pages is pretty thick, so we're only going to cover 279. One of the things that, from my experience, and you can read the bio, but my last 10 years of federal service, I was the director of BI law enforcement in Washington, which was an eye-opener in many ways. So I think I speak with a little bit of experience in that regard. And one of the things that was always number one focus in dealing with tribes as far as law enforcement and detention was the lack of resources or the shortage of money. Now, when we organized, I was fortunate enough to be appointed by the president, our first meeting, I and some of the colleagues we're very adamant that we just didn't want to do a report that's going to be the same as any other report. We've been studied enough. We know the issues. But we want 100% tribal input on what it is that we come up with. Something that's reasonably doable and hopefully garners widespread support. Now, just real quickly, I testified before the Senate when the law was being created, and if you look at the testimony, I testified that there should not be an Indian Law and Order Commission. It's a waste of money, it's a waste of time. We already know everything. And it's on record, and I didn't really care, because being on the inside for all those years, 26 and a half years in BI law enforcement, starting out from the streets, I thought, we know what the problems are. Shortage of resources, distance from courts, all the stuff that we cover in here. So we already know it. Don't study it again. Well, when I get a call from the White House during the vetting process, I'm wondering, I wonder if these guys really read my testimony. Well, they had. And so, being it was a non-paying job, they offered it. But in any case, resources. There's a 2010 report that essentially says Indian country, not even including 280, is about 50% shy of being comparable with off-reservation policing. That's per capita. I think the national average, they say, that law enforcement agencies strive for is about 3.5 officers per 1,000 residents. We're nowhere near that, about 50% down. So that kind of puts it in perspective of where we're at. Now, we in Indian country today are 50% down. 280, I guess you could say, are 100% down. So, that's just something. Commissioner Getty mentioned a couple times on the BIA's effort. They call it the High Priority Performance Goal, which essentially was a 2-year program. They picked out 4 different reservations and essentially just put a whole bunch of cops there, which is good. They got into the preventing crime mode, which I think all law enforcement ought to do. If we prevent this stuff from happening in the first place, we wouldn't have to react and have all the jail costs and the court costs and everything else go along. But it was really a no-brainer. You know, you have more cops on the street, chances are there's going to be less crime. I got 30 minutes. Okay, thank you. But in any case, it goes to prove that more cops. The downside was they took cops from other reservations to help out the 4, which, you know, crime went up over there, I presume. There was no resources for courts, for jails, for prosecutors, for public defenders, that sort of thing. So bottom line was more cops. In our review as a commission and listening to tribe after tribe after tribe in particular, one of the giant criticisms was grant funding. That, you know, these are 3-year grants for the most part. We really hate to hire anybody because they're going to make us resume the costs once the grant goes away. So that problem was always there. You read in our report, we're saying, let's develop a formula. Probably not really so much one size fits all, but if we have some rhyme or reason on providing money out there, it ought to be fair, because it's not fair at all. Believe me, I speak from experience. The way the money is doled out or not doled out. But I think in this report, and I'm probably being a little selfish, I ask you, spend a couple of minutes on page 85. And it's under overlapping functions. And essentially what we have there is Department of Justice doing its thing, the Bureau of Indian Affairs and the Interior doing its thing. And believe me, we heard horror story after horror story from tribal folks and others where that connection was not exactly even. Example, building a jail, DOJ, there's no money to staff it. There's a number of jails sitting out there empty because somebody forgot or either failed for whatever reason, didn't get the money. We are recommending, and this happened once before, it got a little ways in 1997 under the Reno Babbitt years. I was back there. Our thought is, my thought then was, Interior is land management, Grand Canyon, Yosemite, that sort of thing. Why don't we take this law enforcement component, the criminal justice component, the public safety thing in BIA and move it over to DOJ? Because chances are a lot better that we would be properly funded if that were to happen. For whatever reason, politics primarily, bureaucracy, it didn't go anywhere. But we resurrect that thing starting on page 85, and I think we come up with some pretty good reason on why that should happen. This time we're saying, allow DOJ, allow tribes to continue to contract 638 compact the programs if they want. Let's continue the Indian preference for hiring. But in any case, any new legislation that creates this new office over in DOJ, it's certainly got to affirm that, the trust responsibility is still there. So it's not impossible. I'm wrapping it up. Do that song thing. It's not impossible. It's been done. It was done in 1954 with Indian Health Service, with the IHS. And so we're saying it's done in education, EPA, and all these other programs that have gone to better homes, supposedly. I just can't imagine Indian Health Service still being with BIA. So.
So we get to do 2, strengthening tribal justice and detention alternatives. Apparently, Ted is worried I need 2 microphones. I'm pretty sure.
She always demands that.
So I am Teresa Pauley, and I'm the Chief Judge of the Tulalip Tribal Court, and I also am the Associate Justice on the Colville Tribal Court of Appeals, and I hope everybody in this room is amazed at the credentials on this commission. So you have people who are actually on the street who are doing the day-to-day work, be they former U.S. attorneys, be they law professors, who has a student, I think, absolutely everywhere we went in Indian country, to tribal court judges, to people who work in tribal police departments, to state attorney generals. You have people from populated states like California, and no offense to Wyoming, but rural states like Wyoming. So you have not only from a political perspective a group of people who come from many different walks in their political views, but you also have people who come from very different perspectives on the ground. So I think that gives such huge credibility to the unanimous nature of this report. Strengthening tribal justice and detention alternatives, I think the buzzword for both of those chapters is the same. And actually, if you'll notice when you look at them, these things kind of play together. But there's two important things I want to point out. Number one, the commission treated them together. In most of Indian country, the justice system is from beginning to end. It includes the police, the prosecutors, the probation department, the judges, the public defenders, and you can't look at justice systems in Indian country just in one piece. So when the chapter on strengthening tribal justice lays it out as one system, that's how most of the justice system operates in Indian country. They have the safety of their community sort of on the line at every level. So public defenders in Indian country are as close to their communities as prosecutors are in Indian country, and they are the closest to providing the local solutions to crime, which is really a local problem. The second message I hope you get from that chapter is parity, 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 parity. I recently had the luxury of going to the Tribal Nations listening session in Washington, D.C. Every tribal leader said that. Every tribal leader that came before us on the commission said the exact same thing. We need the same amount of money flowing to our police officers, the same amount of training and money flowing to our prosecutors. We need base level funding for tribal courts. Tribal courts shouldn't have to get funds because they apply for a drug court grant. That's a little bit of the tail wagging the dog. And honestly, that's how a lot of tribal justice systems are funded, by whatever the Department of Justice thinks is the best practice of the day. The exact same thing is true in funding detention. So if you look overall, what these two chapters really talk about is parity. That tribal justice systems, and remember I'm saying the system, that's how we view it from beginning to end, have to be funded at the same level. And we honestly think it should be funded by the experts. Bureau of Indian Affairs is not an expert in any of those things I said. They're not police experts. They are not experts in prosecution. They are not experts in public defense. They're not experts in being a tribal court judge. They don't have that expertise. Where does that expertise lie in the federal system? Well, of course, it lies in the Department of Justice. So consolidating that, because I have to say this, we're all pretty sympathetic to that. Give tribal courts and tribal justice system money. That's kind of a hard thing to recommend if you're a commission living in this political climate where we couldn't even get the report published because there was a shutdown of the government, right? So how do you fund this in a way that makes sense? You fund it by better use of your resources, consolidate it into one agency who's in charge of it, and provide base funding as opposed to the grant of the day. So those are absolutely critical. When you're looking at tribal justice systems, because remember I said what you have to do is look at it holistically. There's a reason the chapter is structured that way. We've had great success with tribal prosecutors partnering with U.S. attorneys, and it's actually provided for in the Tribal Law and Order Act, and they're called SAUSAs, Special Assistant U.S. Attorneys, where those Special Assistant U.S. Attorneys can actually prosecute federal crimes in federal court under the tutelage of the local U.S. attorney. I have to tell you, in places that have SALSAs, the results were absolutely dramatic and amazing. They have weekly meetings between tribal prosecutors and federal officials to decide if they're going to prosecute if they're going to prosecute tribal or if they're going to prosecute federal. If they want to do a federal prosecution, maybe probation is better in the tribal system. If they want to prosecute tribal, maybe probation is better in the federal system. That whole gamut of choices that opens up when they're partners instead of one versus the other makes an amazing difference. We also postulate that public defense is absolutely critical in Indian country. I'm a huge proponent for give all of my criminal defendants all of the rights that they have under the United States Constitution, and it doesn't make any difference to me if they're Indian or non-Indian. That's my job as the judge, is to protect their constitutional rights. Well, if you have special assistant U.S. prosecutors, why can't the Federal Public Defender's Office have special public defenders that are tribal public defenders that work with the Federal Public Defender's Office? What a great idea. And once again, all about parity. It's not something that we think about every day, but using those systems to train each other, to support each other, to help each other is going to make a dramatic difference in Indian country. And by the way, it's not expensive. So that's sort of the key, just thinking about it in a different way. So we also made a couple of recommendations with regard to the federal court system. You know, there's lots of literature out there, and one of the chapters specifically highlights how foreign the federal court system is to tribal members who are actually tried and convicted. How juries don't have Indian participants on the jury. How witnesses can't get to the courthouse, or more important, the victims or their families can't get to the courthouse. How is that right? In this day and age where we should be tried by a jury of our peers, how's it right when there's no Indian faces there? So we actually proposed and heard great testimony from some federal district court judges that it should be part of the federal court program to have locations that are closer to Indian country. We heard of a couple of federal district courts that do that. It's not that hard and it's not that expensive. And if you want to allow tribes to do all of that prosecution and eliminate those costs, then this is pretty simple. The money should go with the person. So if the tribes are doing the work, they should get the money. And I absolutely, positively guarantee you, no disrespect to my federal counterparts, but I can prosecute a case to its conclusion much better than the federal court system can, and much cheaper. I didn't get to talk about very much of my real love in the world, which is in the alternatives detention section. But I hope that you see that sort of what I said earlier when I was visiting with Professor Clinton after his talk is just absolutely true. When you give tribes and tribal courts in particular the ability to look at alternatives to detention, they can do amazing work. So Tulalip tribes saved over $100,000 in detention costs by just changing the way they do business, which, by the way, is a much more tribal value. Hold people accountable for their actions. It doesn't necessarily include jail. So ask the tribes because they can do it better. There also is the Leech Lake example, and there's some great examples of alternatives to detention. It's at that moment in time when tribes can fulfill the requirements of the Bill of Rights and they can do it in a tribal way. It's at that moment in time that all of the promises to all of our ancestors will have been met.
Thank you. My name again is Dorothy Alter. I'm the Executive Director for California Indian Legal Services, and I just want to thank the Commission and inviting me and being on these very prestigious panels. I'm not a law professor. I'm just an Indian lawyer working out of our Escondido office. When I was asked to be on a panel, I frantically emailed Carol and Ted and said, what do you want me to talk about? And Ted said, just talk about your lawsuit. So I'm going to talk about a lawsuit that I did that actually this report addresses a lot of the issues that came out of that lawsuit. I represented a tribe, the Los Coyotes tribe, which is a small tribe in rural San Diego County. They had started a law enforcement department with a Department of Justice COP grant. And after 3 years, the grant expired, and they then sought a 638 contract through the BIA for law enforcement funding. The contract was denied on several grounds. The denial letter, we were fortunate because the people writing it weren't real careful in their wording. But the first thing that they said is that we're denying this because you're in a PL 280 state. The state has criminal jurisdiction responsibilities and law enforcement responsibilities, not the federal government. They then went on to say that under the Indian Self-Determination Act, a contract cannot be approved if the amount that you're requesting exceeds the amount that it would cost the BIA to provide the same service. Because we're in a PL 280 state, they provide no services, so anything over zero amount requested would exceed the amount of the services they're providing. So we sought an informal conference, which is provided for under the federal regulations, and we had the solicitor from Phoenix come out and special agent in charge, and so through the course of the informal conference, the representatives from the Bureau admitted that it has been a long-standing policy within the Bureau that they do not fund tribes in public law 280 states for law enforcement because under PL 280, the state has concurrent jurisdiction with the tribe, and they actually provide that level of law enforcement. They also admitted that there were certain circumstances where tribes in public law 280 were in fact receiving 638 funding. These are tribes that in California straddle between Arizona and California. So Arizona not being a public law 280 state, they do receive law enforcement funding. So we, of course, called those tribes and said, do you use any of that 638 law enforcement funding on your California side? And they said, of course we do. So anyway, the informal conference went very well, and the recommendation from the department's designated representative was that they should fund us for law enforcement. At that point, there was IBIA appeals, blah, blah, blah. Ultimately, we went into court, and because they decided not to follow the recommendation of their designated representative, we went to court, we sued them on several grounds, one of which is that they violated the Indian Self-Determination Act because it's a very narrow statute on when and how the Department of Interior and Indian Health Service can add additional requirements and limitations to declining or a contract. And what we argued is this policy is what we call a non-regulatory requirement that they've added that in order to qualify, you can't be in a public law 280 state. We also argued the APA that this policy constituted a rule that should have been promulgated per the procedures of the APA. We also argued that it violated APA because it was arbitrary, capricious, and all of the rest. We also argued equal protection violations since there are tribes in PL 280 states, very few, but they do receive funding. Therefore, they're discriminating against my client. And then, of course, we argued breach of trust, and we were very successful at the district court level. The judge ruled in our favor on all counts except the breach of trust claim. After that, we, of course, called the Office of Justice Services, asked when the check would be coming for our contract. I was politely told that a notice of appeal to the Ninth Circuit was in the mail. So we go up to the Ninth Circuit, which the hearing went really well. They just hammered the U.S. Attorney's Office, which made me feel very good. But at the same time, I do believe that they really struggled with the relief that we were requesting. And if you read the opinion, about the first 4 pages are very good. I'm right there with them. You know, they're talking about high crime rates, you know, in Indian country, the lack of effective law enforcement, and all of a sudden they just turn around and hammer me. They found that there was no review of agency action on allocation of lump sum allocations. So therefore, there was no review of how the BIA divides up their money. There was no equal protection claim because there was a rational basis why they gave money to certain tribes in Public Law 280 states and not others. And then they also agreed, which I think is probably the worst part of the decision, was the government's interpretation that if they are not currently providing the service that you're contracting for, then you can't apply for a 638 contract. And because there is no legal services or law enforcement services in California being provided, there's nothing for us to contract for. Well, if you take that to its logical conclusion, that this is not just limited to law enforcement. This is going to be tribal courts, which are not funded in California either. So essentially what the court or what the BIA is saying is, as long as we never support law enforcement in California, we never have to give you our 638 contract. It was a very hard decision to accept. We had worked hard on it. It was 3 years of litigation. And then thanks to Turtle Talk, as I was reading it, it suddenly was blasted through Indian country, as well as, you know, Pechanga.com, the worst case of my career, and of course it's all over Indian country. And now I'm a panelist to also talk about the worst case of my legal career. But that being said, when I got the report, I was elated. And I'm sending it to everybody. And sort of a common comment coming back was, did you write this, Dorothy? You know, because it really honed in and hit on every single issue that I see that my clients struggle with. I did note that the quote in the report from me is dismantling the Office of Justice Services that someone asked me during consultation, to which I responded yes. I really think, along with the other commissioners, that if you look at what the BIA provides, I mean, housing is handled under HUD. Healthcare is under, you know, Health and Human Services. Environmental is under EPA. It just, to me, makes logical sense that law enforcement and courts should be under the Department of Justice, and leave to the BIA those responsibilities for trust assets. So they did such a bang-up job with Cobell that, you know, we'll leave that with them for a while. So anyway, that was one of my comments during the consultation. I was really pleased to see that as being sort of a centerpiece of this report. The other part that I found extremely helpful, and I really want to thank the commissioners, was the recommendation to provide equal funding, available funding for all tribes, and it includes tribes in Public Law 280 states. The other recommendation that I was so pleased to see is that funds should be provided tribes whether they have a 638 contract or they do not. And I underlined "or not" about 10 times because I really felt that was a direct response to my Ninth Circuit case. Also, I was very pleased on the base funding, getting away from this grant funding, competitive funding. I think my client is a very good example of starting a law enforcement department with, you know, Department of Justice COP grants, which is a great program, but it's seed money. It's to help you get it going. Once it gets going, then you're on your own. And I sometimes wonder, does the Department of Justice ever talk to BIA? So DOJ is giving us money to start this department, and then we go to, you know, BIA to say, okay, can we have our 638 money to support it? And they're saying, no, you're in a public law 280 state. The only other things I just want to touch on, just for the sake of some of the commissioners, I did note that there was a recommendation about collecting crime statistics. And recently I was given a report of the FBI crime data, and I noticed there were only 2 tribes in California that were in that report. CILS represents the California Tribal Chief of Police Association, so I sent an email to all of our chiefs and said, what's up with this? Why aren't these statistics being collected and turned in? And just for food of thought, a lot of the departments told me is that they do collect their crime statistics and they turn them into the BIA. And from there, they don't know where they go. So that might be something we're going to try and follow up with within the association to say, hey, what are you guys doing with our statistics? The other thing is, and we do have Riverside here, I was also told that a lot of those statistics get counted by the county sheriff if they get called out to the reservation. So sometimes the tribe doesn't collect that, but the county can. I really like the idea of having an insurance pool. So as you all know, when you're trying to negotiate with the state for legislation for peace officer status, the big thing they hit you with is sovereign immunity, you know, and the ability to pay if there are some type of liability against your officers. And this is just a final note, and I'll be really, really quick, because I am a legal services organization. I did note that the recommendation for LSC, which Legal Service Corporation, for years we were prohibited as legal aid lawyers to represent criminal defendants in any capacity. Under the TLOA, they amended that now allows legal aid lawyers to represent indigent Native Americans in tribal court on criminal offenses. The Indian legal services community has been in quite a buzz about this. One is we're not criminal lawyers. And I was a prosecutor at Suquamish years ago, but like I said, for most, if not all of the legal aid lawyers that I've worked with for 30 plus years, we don't do criminal law. And so I think it'd be a real learning curve to get us up to speed to go in and do a criminal jury trial. The other thing is we have a real conflict of interest. Most of the work that we do in the area of DV, we're in there representing, or wanting to represent the advocate. I mean, we're advocating for the victim. So it's kind of a weird position you're putting us in, that we're writing grants to get money to help the victim, and at the same time the court's appointing us to represent the defendant, who's the perpetrator. And then finally, one of the things with the VAWA, passage of VAWA, and we've talked considerably among the program directors, is, you know, this is just not going to look good in our Indian communities if we take our legal services funding and we're representing low-income, non-Indian defendants in DV cases. because that's not really what our mission is. That's not what we really are about. And so I think my recommendation would be, not that I would oppose more funding for LSC. I really think when it comes to trying to do public defender programs, I'd rather see that money directed directly to the tribes so that they could, and not use your local legal aid program as a public defender's office. Thank you.
Thanks. So I don't know what else there is to say. It's all been said. So I'm Matthew Fletcher again, and I'm going to be talking about these chapters, tribal alternatives to incarceration and tribal justice systems. And this, I think, is where this is the tribe side of the commission report, and this is where tribes need to be strong in asserting their good native governance, their good sovereignty. And this is where it just almost disheartens me to hear commissioners report that when they go to Indian country, people tell them we need more cops, we need more jails, we need more money to put people in jail, and in exchange for that, we will give you, apparently, a legal aid attorney who doesn't really want to represent criminal defendants for really good reasons. That's what you get. That's what we give to you. And I'm, again, this is just me trying to be provocative, but this is in some ways what's happening here. Now, I love these chapters. This is part of the life's work that I do, and I think that it was an absolute pleasure, especially to read Chapter 5. This is some of the most important work I've seen ever come out of an Indian Affairs Commission or thought project or any kind of article or scholarly or policy position paper of any kind. It was amazing to read this, and I'm deeply, deeply impressed and thankful that this is here. So my thought on this panel, at least the way that I approached it, was to say these are the tribe's obligations, and so this is the other side of the sort of a continuation of what I was saying before about in the earlier panel about this report about Indian country criminal jurisdiction. Where are the tribes here? And I think somebody said it earlier just a few minutes ago that if you give tribal courts a chance to be creative, you give them time and resources, political backing, all sorts, and whatever they need to think about these things, you'd be pretty amazed at what they can come up with. And you often hear about tribes that have followed through on and influenced and inspired by Navajo peacemaking programs. My wife's tribe, Little Traverse Bay Bands of Odawa Indians, started. I guess you just call it a drug court, but what they call it is Wabshki Miigwan, which means white feather, and it's named after the story that a former Little Traverse tribal judge told her son in the language, basically on her deathbed, about actually going to Alaska and acquiring a white feather, an eagle feather, from, of course, the town dump in the village of Cake. And so what they came up with was inspired by this story of this Wabshki Miigwan. And that is just one example of how tribes, tribal court, tribal justice systems, tribal policy public policy leaders, policymakers can be creative and come up with new and different ways of dealing with Indian country crime and law enforcement issues. And I think tribes have been doing this for a long time. And part of what's been said on this panel is that the structure of federal grant funding has killed so much tribal creativity. And I don't want to give tribal leaders, get them off the hook either. They're the ones testifying about how we need more cops and we need more law enforcement. And we need to put people in jail for longer and longer periods of time. They're talking about their own tribal members. So they need to be creative too. I recall a story I heard. I used to work in in-house counsel at Hoopa, and people in the social services department there claimed to have started the first women's shelter in the state of California and I can't remember if they said it was the 80s, early 90s. And basically what happened was they got a grant, probably a 3-year grant, from the federal government to start a shelter for runaways. You guys remember the 80s when Runaways was a big deal? It was on a very special episode of Different Strokes or whatever. It was about a runaway. And, you know, Soul Asylum had a song about runaways. Well, they got money. They bought a house on the reservation. They renovated it, started a shelter for runaways. And the only people that came into the shelter were these kids who were running away from domestic violence situations. And it wasn't working out at the shelter until they started bringing the runaways' mothers in. So what started as a shelter for runaways really became a women's shelter, women and children's shelter for domestic violence. And it was incredibly successful for 18 months or a year or two that they had it going. And then when the grant ran out and they were preparing to get it renewed, the federal government said, we want our money back. You didn't do anything that you said you were going to. This is supposed to be for runaways. And this is just a tiny story of what can happen in Indian country and what has been happening over and over again. All right, so that's the stuff I want to say about alternatives right now, and I'm going to be running out of time. My clock quit, so I don't know how much time I have left. But I really want to talk about tribal justice systems a little bit too, and I'm not going to spend too much time talking about this. Those of you who know me can tell when I'm completely making stuff up when I start telling anecdotes about things. So I'm going to start with 2 anecdotes, and I think they're really funny, and it gives you a sense, maybe a little bit of a leviness. And there's 2 Indian lawyers who were law school classmates, and both have been highly influential in me in terms of how I think about tribal jurisprudence. The first story is from Mike Petoskey, who is a chief judge for multiple tribes. In fact, I think he's been a judge for every tribe in the Lower Peninsula in the state of Michigan, and has helped to start many of the tribal courts in Michigan for the Ottawa and Potawatomi tribes there. He said at he started his first judgeship was at our tribe. We're both members of the Grand Traverse Band, and he had a guy come in he had known since he was a kid who was committed some sort of misdemeanor, and he was sitting in court. And the courthouse is still the same courthouse as it was before. It's sort of a small building, and it's in the shape of not a triangle, a square. It's very rough edged. There's really nothing. It's very an adversarial type thing. The judge looking down on the 2 parties. This guy walked in and said, "This looks like a white man's court." And what Mike will tell you is that he took that very seriously. And yes, the court is an adversarial justice system type court, but he does a lot of things to try and leaven that. He's actually encouraged tribes, including Little Traverse, to establish a courtroom that is circular. And in fact, if you go to the Michigan Supreme Court, their courtroom, although very adversarial and hierarchical, is also circular. And that's inspired in part by Mike's recommendations. And the second anecdote is from Ray Austin, who is a longtime Navajo Supreme Court justice. And he came to give a talk before us years ago at a tribal justice conference we held at Michigan State. And to talk about the lack of resources he had as a sitting judge, and how he needed all the legal research and writing assistance he could possibly have. He was basically doing it on his own, and he needed help. And he said that for a couple of weeks he sat in an exchange program years ago, the Arizona Court of Appeals. And they apparently sent judges to Navajo, and he sat for a few rounds of cases in the Arizona Court of Appeals. And they introduced him to these recent law grads who were the Arizona Court of Appeals clerks. And he had no idea what they were there to do. And he said he was sitting in a room with them. And he go, "Well, what are you going to do for me?" And they said, "Anything you want." And he said, "Go make a sandwich." And I think they did. So the point of this is that tribal courts in many ways are running in bare bones operations. And at the same time, they're doing pretty amazing things creatively. And I guess what I want to say is that I see, to come back to this notion of alternatives to incarceration, like I said earlier this morning, I've only sat in 2 criminal cases as an appellate judge. And I thought neither one of them, it wasn't my job to talk about this in the opinion or even really in the deliberations. But the cases are long done now, so I can comment on them, I suppose. Neither one of them needed a prosecution at all. And I think that there are so many cases that go through into misdemeanor court, tribal court, that have no business being there. The first one I could think, the first one I'm talking about is a guy who actually was a sitting appellate judge for the court in which I was sitting. The other appellate judges had recused themselves because they had worked with him, so I was a conflicts judge, so to speak. And he had been prosecuted for something I'd never even heard of before, which was called attempted embezzlement. I'd heard of attempt and I'd heard of embezzlement before, but never, I guess, failed embezzlement. And I guess it makes sense that it's a crime. He tried to trick the tribe into giving him some money that he wasn't entitled to, and he got caught. He didn't get the money, so it wasn't embezzlement. But he was prosecuted, and I thought, and he thought this too. But he was a non-lawyer, and I don't know. As they say, he was representing himself, and fool for a client. But he was making some arguments based in tribal tradition that were a little bit uneven and didn't really do him any good at the appellate court level. But I think what he was basically trying to say is this really a crime? And the answer technically was yes. But it didn't have to go through this process. And I found that my suspicion was if he hadn't been a sitting appellate judge, he would not have been prosecuted. It may have been dealt with as a matter of employee issues or something like that. But a lot of the arguments he made, I thought, were sort of desperate pleas for a recognition of some sort of traditional justice system. And my favorite argument that he made, which again, like I said, didn't do him any good, was that in Anishinaabe, in the language of Michigan Indians, it's there is no word in the language for attempt. It's like Yoda, either you do or you do not do. There is no try. And he's right. I went and looked it up in a lot of Ojibwe dictionaries. There is no word for attempt. You're either doing it or you're not. And I mean, obviously that's an interesting argument. It didn't get him very far because the criminal code was clear. But he argued for a traditional jury of elders. And he had all these ideas that really out of desperation, because he knew he was being criminally prosecuted. But they were worth our time to at least consider. And yeah, it didn't do him any good in this particular case, but I thought it seemed weird to criminalize this really stupid action that this relatively young guy had done. I'll skip the other case just out of a sense of time. And the last thing I want to talk about, I think, is the concern I mentioned earlier about I guess I'm getting off topic. I was going to talk about tribes, but now I guess I've got to go back to the Supreme Court. Tribal justice systems do a lot of things that are remarkable, but we have a lot of thinking to do about how to deal with the fact that we are trying to criminally prosecute non-members. Non-Indians is included in that group, but I mean non-members. Indians who are members of other tribes or indigenous peoples from other nations. And we have to address the dissent in the VAWA reenactment. I am part of this. This is part of the reason why I'm concerned about this, because I'm part of it. I run a blog that I pride myself on opening up what it is that tribal courts are doing, what it is that state and federal courts are doing, what it is that tribes are doing. The whole goal is to inform everyone. Anybody who is interested in this should know as much as possible. And what I've seen since I started the blog is that the only news I get out of tribal courts is bad news. And it just shocks me. I'm amazed that tribes don't advertise what a great job they're doing. No tribal courts or tribal litigants send me appeals in cases where they've done something remarkable. What I do get a lot of is, here are all the briefs and all of our complaints over and over again about I'm being disenrolled. Me and my family are being disenrolled because we're Filipino. I get that. Or I get the tribe doesn't like me as a business partner. Sorry, sir, Ted. So they're going to take my property away from me. I get a lot of that too. And I want this stuff out there because I'm hoping that tribes will start doing better. And that's what it comes back to when I talk about tribal leadership. And tribal leaders do need to do better. And I don't know if that's actually going to happen. As my former boss, John Petoskey, used to say, the only thing you need to be a tribal leader is a pulse and 18 years old or something like that. So I don't want to sound negative. I think tribes are doing really amazing things. So maybe this is just a plea to send me good news to Turtle Talk for once. And I'd love to read those cases. You know, I think that tribes are doing remarkable things. Sometimes I do read pretty impressive opinions. They're very thoughtful. A lot of them are out of the Navajo Supreme Court or the Ho-Chunk Court. I like to think that some of the work I do with the courts that I do, I know that the judges I work with, very remarkable, intelligent, thoughtful people who are doing really good work. So with that, I'm going to say thank you very much, and we'll talk more.
All right, first I'll give our two commissioners, Judge Pauley and Ted, a chance to comment, and then maybe take questions or comments from the audience.
Yay. I really appreciate the comment on legal services, but one of the things I think that the commission is sensitive to, and maybe legal services is not necessarily the right agency, but developing sort of standalone programs in Indian country is really tricky business. Where does it live? And one of the great features about SALSAs is that U.S. attorneys actually partner with tribal prosecutors. So having legal services, even though that's not typically their role, partner with tribal public defenders might give them that extra legal edge. So I think that was our thought. I certainly would never allow you to practice in my court with that conflict, and I would never put you in that position. So, but I appreciate that, because that was something that I actually hadn't thought of when I thought about legal services corporations. Matthew, I don't know how to send you good news. You know, I'm the repository of bad news, right? If you could figure it out on your own, you wouldn't come see the tribal court judge. So I'm really going to have to, I mean, I take that to heart. I think that's true. But I'm the person that you come and see when you violated the law, when you can't get along with your spouse, when your neighbor's dog is barking, when you slip and fall at the casino. So those are all, that's sort of tricky business. But it raises a really interesting point, which is tribal courts are constantly under criticism, and I think we saw that with VAWA. About their competency or their legitimacy, and how does a court system go about the business of spreading the good word. So I think that was, for me personally, Matthew, that was really useful, because I have to think about that. Because you're right, tribal court's going to be under the spotlight really soon. Department of Justice has applications in its hand to allow tribal courts to start prosecuting non-Indians. So we need to sort of be prepared for the public relations thing that goes along with that. Those are my thoughts. Oh, you need my microphone? Oh.
Not so much rebuttal or response, but it's going to be the last 2 or 3 minutes I'll have of your time. So, first of all, you know, thanks to everybody for listening to us, and the people here on the panel. But in going away, you know, believe me, I've done this probably longer than most everybody in this room, and that is on the law enforcement side. And I went everywhere from a young patrol officer wrestling drunks, which I thought was the coolest job in the world, for a while. Then I got smart. But, you know, from there to putting people in jail was, you know, satisfaction. And I think as you get older, especially if you move away from the action, so to speak, I've often wondered, and I've talked to many folks, smart people, people like yourselves, and I'm just thinking, you know, putting people in jail isn't really working all that well. Now, believe me, some need to go to jail. There's some serious offenders out there. Tribal people demand they be put in jail, and they deserve to be in jail. Those that abuse their children, their spouses, they have to go to jail. But while they're in jail, there should be some sort of mental health services, because clearly there's issues involved. I think we talked about the alcoholism, the drug abuse, all on so-and-so. But what I'm getting at is that in the hierarchy of things, trying to prioritize, you know, the chicken or an egg type thing, I often wonder now, in my older age, maybe if we prevented this stuff from happening in the first place, by we, I mean tribes, maybe through education. We'd much rather build libraries and computer centers and boys and girls clubs and all the good stuff than jails. I first got to agree with that. But I think that's where it starts. Tribal leadership is in the driver's seat. Sometimes I really hate to use leadership with some of the stuff that I see some folks doing. But the elected officials, the community leaders, the service providers, the parents, to me, that's where it all begins. That's who should be in charge. We just come along, we, the government, provide the support necessary to make sure that they succeed in whatever they prioritize and do. And to me, it's education and prevention. If that would work to a certain degree, all the aftermath, the jail cost, all the misery that occurs wouldn't happen. Now, I'm not being ideal. I'm just thinking that I've tried in my career different things. Some have worked, some not worked so well. But prevention, education. Now, this report, I started out saying it's 280 pages. It's thick, it's heavy. You hate to lug it everywhere, but I do. And I just hope that people like you, with your positions and your expertise, that you pick out some part of it, maybe not the whole thing, but whatever applies, and then you promote it. Because it's a shame if this thing dies like some of the other reports we talked about this morning. It'd be just a terrible shame. Now, if you're a little lost or wondering which part you ought to pick, feel free to pick page 85, the overlapping functions, because seriously, that is, to me, that's a big part of the pie. And that if we continue to do this thing, with DOJ doing this thing, the BIA doing this thing, they're going to be talking about this 20, 30 years from now. So it's got to start somewhere, and to me, that's as good a place as any to start, revamp it, make it work. But tribal leadership has got to be the answer, period.
All right. Comments from the audience? Angela?
Well, thank you all. I have a question that I hope will make sense, and I guess it goes somewhat mostly to Matthew and to Judge Pauly, but in general. So it seems like a lot of the positive things that have come out of tribal governance in the past 20 or 30 years, and maybe much longer than that, are creative things that are developed because of the space between what is allowed under federal law and arises from maybe just from an entrepreneurial spirit, or maybe from something specifically tribal. So there's a space that's created, right? And we can imagine lots of those. Maybe it's gaming, maybe it's other things. So in terms of alternative dispute, not alternative dispute resolution, but alternative punishments, one of the things I think about is if we're talking about prosecution of non-members, regardless of whether they're Indian or not, I think there's a whole different level of scrutiny, and there's a whole other ball game and can of worms we have to think about. But if we're thinking about prosecution of actual tribal members, what is that creative space? So other than like the peacemaking court, there has to be some creative space there, right? Because the limitations of ICRA means that there's some room, and there's some room for creativity. And we've seen it in some ways, but I'm just really curious, because I know there's obviously an enormous national critique going on of the criminal justice system. People agree that jails are not working. They're not working in general, so they're not probably going to work any better in Indian country than they're working elsewhere. So what is it that we can do with that creative space? And I would love to hear your thoughts on that.
I have a lot of thoughts about that. And part of it has to do with what I was going to talk about this earlier, but what I'm starting to refer to as the federal hammer. And what that is, the idea for it comes from really the Pokagon tribal court, and not even in a criminal context, but the Pokagon band of Potawatomi Indians, Bob knows about this, same meetings that I go to, they started issuing civil citations at the casino for drunk and disorderly. There's a dude who came into the casino with a gun and it went off, and so they started issuing citations to these guys. Most of these guys are from Chicago. They're from way out of town, and they don't know anything about tribal governments or tribal courts. But they get arrested, or at least issued a civil citation, and they're sent on their way. And then after 30, 60 days, whatever, they don't pay their offense. The tribal court clerk, I don't know if he's still obligated to do this or somebody else does it, but calls them up and said, hey, you didn't pay your $275 fine. Are you going to pay it? And the answer invariably is probably, well, no, I don't know who you are. And okay, well, thank you. We'll just turn it over to the United States Attorney's Office in the Western District of Michigan. And 70% of the time, I think, Steve said, they get a check in the mail. Now, that's the federal hammer. It's all illusory. The feds have already declined to prosecute in that instance, right? But Charles Barkley from Chicago doesn't know that. So I mentioned Charles Barkley because I met him at the Pokagon Casino once. But not that he was doing anything wrong. So, but this is interesting because think of all the things that tribes can do. Now, I mentioned earlier that, let's say, somehow, tribe figures out, we got all of this jurisdiction, let's just not put people in jail. Let's not invoke the adversarial process. Let's just be all hippy-dippy, be traditional, just come up with something completely what most people would think is ludicrous. We are not going to punish anyone, really. We're going to try every avenue we can possibly think of with this person, no matter perhaps how badly they've behaved. Maybe there are exceptions to that rule, whatever. But there are a lot of things that you can do to try to integrate people back into the community, to remediate, to restore restorative justice models, whatever. But in the background, one thing I'd like to see is that federal hammer. So, you know, let's say you get this guy who is a repeat DVU offender, and you don't necessarily want him to be that 19-year-old kid who's going to be in federal jail for the rest of his life, in and out, because he was a DV offender when he was 19 and 20 and 21. So the tribe does something. I don't know what it is. They have to be creative. And it should be in line with their customs and traditions or what they think is right going forward. But in the end, the guy just might not take with it, right? You just have to throw up your hands, and that's where you call the United States Attorney and say, all right, he's yours now. You have to have a structure and a system in place to make that happen. And I don't think the Indian Law and Order Commission report is recommending anything like that. But that's where you get the space. That's where I think you can get some serious creativity that might actually work without ever actually putting anybody in jail.
Figure out what it is you want to accomplish. I think I've heard from Professor Fletcher, and I heard previously from Professor Clinton, and I hear this all over Indian country. You know, what is your purpose? Is your purpose to punish someone? Or is your purpose to change their behavior? So you have to ask yourself that question first. What is the purpose of your criminal justice system? In Indian country, at least for the tribes that I've worked for, so that's my own tribe, the Colville Confederated Tribes, Tulalip tribes, and I've also worked for the Lummi tribe. What they want to do is change behavior. These are people they've lived together with since the beginning of time, and they're going to live together until the end of time. So they have to figure out how to repair the tear in the fabric of their own community. So how they do that really is alternative to sentencing. The Department of Justice shouldn't write a check for a detention facility if what Tulalip wants to do is have a halfway house so that people who are newly clean and sober can be clean and sober in a halfway house, but the only way they can get that is to write money for detention. We saw plenty of beautiful detention facilities that were built by the Department of Justice that didn't have any staff because the BIA didn't fund that. So that whole process or idea of detention facility, I think, is a tribe's choice. Amazing stuff happens. I can't even tell you how amazing the things are that happen, from having elders panels to visit with offenders to doing diversion programs. We have a community accountability board that visits with youth offenders. Treatment is absolutely the key. Isn't that what you want? Don't we really want the people in our community to be clean and sober? And if they're using drugs and alcohol because they have a mental health problem, so they're self-medicating, wouldn't we rather treat the mental health problem? Do we really want to throw people in jail for those issues? Or do we want to look at sort of the underlying causes? And frankly, in Indian country, for some of my clients, the underlying causes may be a disconnection from their family or their spirituality. I'm not going to order them to go to church, of course. But you can create the space to allow them to make positive choices and reward those positive choices. It's nothing in due process says you can't reward positive choices, right? Reward those positive choices because there is space in that. Now, if you're going to throw somebody in jail, make sure that you take care of their constitutional rights because we're the caretakers of that. But that doesn't say anything about all of the millions of things you and your community can do to repair the tear in the fabric of your community. So that's a tribe-specific.
We had a question over here.
Thank you. I actually have a question for Commissioner Kasula and Commissioner Pauly about page 85. Actually,
Our
page
favorite
87,
page.
but I thought maybe I could extend over. And it also relates to a reference you made about 1997 and the discussions that I think culminated in the creation of the Office of Justice Services, BIA. But an important element, I think a critical element that's in the commission report that wasn't in those earlier discussions about taking the law enforcement function out of the Department of Interior and moving it over to DOJ is a point you mentioned, which is, and it's in the report, ensuring that tribes have the opportunity to contract or compact with the Department of Justice under the Indian Self-Determination Act. And the report, I think on page 85, talks about NAHASDA, the Native American Housing Assistance Act, Self-Determination Act, contracting under ISDA, under the Indian Self-Determination Act, is not permitted there. Obviously, it is with Indian Health Service, and there's also Department of Transportation is working through this. But I'm wondering if the commission had the opportunity to talk with officials at the Department of Justice about the consolidation, but also importantly about the contracting under the Indian Self-Determination Act, and if so, what were their thoughts on that?
You know, if you look at our website, it's IndianLawAndOrderCommission.com versus Gov, and so we're totally independent aside from them. And sitting down one-on-one as a group, probably no, but otherwise, yes. Great answer. But just from experience, I voiced that that's probably where we messed up the first time we tried to do this. My thought is that had it happened in the late 90s, a lot of the issues that we see today, I don't think would be there. I really don't. It's just totally absurd to have a $5 million jail sit empty. That has never been occupied. There's one in northern Nevada, a juvenile facility that has never, ever, it's about 7 or 8 years old, sitting there. They use it as a warehouse now. It's just totally insane. You get a location that applied for a COPS grant, 5 officers, 5 cars. Makes sense. They got funded 5 cars and 1 officer. I mean, it's I know. But, for those reasons alone. Now, I'm not pointing fingers too much, but if you go to Interior, the budget, and I know, because I used to work like crazy with a lot of help to justify budgets, because I knew that the money was needed, whether for jails or for cops or for prevention programs, training. you work hard to justify it, but I see now, since I left, especially since I've been in the commission, you go back and it's public record to see how much money was left on the table at the BIA. It's just shocking, the millions that they didn't spend, and they want to go back the next year and ask for millions more. You know, that's not going to work. And so obviously, it has to be under one roof. I'm thoroughly convinced that it has to be under one roof, and preferably over in DOJ.
Can I just add? I had a conversation with the Department of Justice official. I think we all, other commissioners, heard this comment as well. But we did our recommendation, get away from grant-based funding and just move to base model funding. And one of the Department of Justice, or I think it's just where this person worked, said, yeah, but what if we see another program that's working? Can't we still just encourage that happening? And so, I mean, these sound like basic recommendations, but I just think the way, you know, if you haven't had a chance to work in big government, these attitudes are extremely difficult to change. So that's just my 2 cents.
Carol?
Well, normally I agree wholeheartedly with Chief Judge Pauly, but I must vociferously protest something she said here today. She described herself as the repository of bad news. And I do not accept that. I'm not even sure she really believes it. Maybe it was just an attempt. But I think we've heard enough from her otherwise today to know that she is actually a repository of outstandingly positive news, namely the things that are happening at the Tulalip Tribal Court. And you know, Matthew, you talked about the problems of publicizing the good things that happen. The Harvard Project on American Indian Economic Development has its Honoring Nations program, and it tried to be an occasion for broadcasting these positive accomplishments. Of course, not that many of them involve tribal courts in particular, although the good news Tulalip tribal courts did get high honors from that program. But we don't do a very good job. Bob Clinton and I serve on the Wallapai Court of Appeals. Most of our docket is actually a criminal docket. There have been actually quite a few cases that I would be very happy to circulate as evidence of the protection of defendants' rights in our courts. There isn't a sufficient vehicle right now for circulating, bringing to the public's attention the decisions of tribal courts. We need to work really hard on that. The National Indian Law Library has made an effort, which is a commendable one, but it's not been sufficient. And I think that is something that deserves really some priority attention, and something the academic community and the practicing community can think about together. One last point I wanted to make about something that you were concerned about, Matthew, namely our references to the clamoring for more police and prosecutors and judges in Indian country. To some degree, I believe that is a product of cultural forces that go way beyond what we do. People have heard me tell this story, but I was up at a native village above the Arctic Circle, a place where you could only get on a small plane landing on a gravel runway. There was one flushing toilet in the entire community in a building that was open 6 hours a day, but they had satellites. And they were getting episodes of Law and Order on an unending stream, day in and day out, as everyone who has satellite television will tell you. Those are influences that affect Indian country as well as everywhere else. At the same time, the research that Professor Champagne and I have done demonstrates that when tribal folks talk about wanting police, they don't necessarily mean the kind of police that you would see on the streets of Los Angeles. The perpetual preference is for community-oriented policing that is far more preventive in its orientation, that is knowledgeable about familial networks and knowledgeable about cultural values, and is in a position to function with the trust of the community, to break the code of silence and really to be partners in improving the lives of members of the community. And so I wouldn't necessarily assume that just because they want more people in that, label role, it means that they want the stereotype non-Indian version of that role.
Bob Clinton in the back.
Yeah, just a question, and it's mostly about the proposal to transfer the overall funding, unify it, and injustice. In some abstract sense, all of that makes sense. I agree with Commissioner Jusilo for the reasons he stated. But one of the developments that's been happening recently is the diffusion of BIA power into other agencies, primarily to move them out of the Indian preference that exists in the Indian Reorganization Act. Moving the overall funding source from BIA to justice, while absolutely sensible in a lot of ways, if it doesn't have the Indian preference attached, which would be very hard to enact these days, may wind up putting more and more non-Indians who are unfamiliar with Indian country in charge of the money spigot. And my question is, given that reality, is that a good idea?
No, I think the Commission firmly agrees that Indian preference in hiring has to go with it. Otherwise, you're right, that possibility is there.
Troy?
Sorry. That's okay. My experience with Bureau of Indian Affairs with regard to justice issues is that they don't know what needs to be funded as a general proposition. So even if you put the money in the Department of Justice, Justice knows why you would need a public defender or a prosecutor, or why you might need 3 police officers. At least you could build a jail that had personnel. So you might build a smaller jail to fund the personnel, but at least you would have both of those pieces. So even though I 100% totally agree with the Commission recommendations, which says there should be Indian preference, I still think it's preferable to have an agency with justice expertise in charge of justice issues.
All right, we got 5 minutes. I'll take Troy, and then my friend from South Dakota, and Addie will get you in.
You know, Professor Fletcher spoke intriguingly, as he always does, on this federal hammer. And it's an interesting concept, and I think it definitely needs to be run around. There's a theme, though, that we have in this report that I don't want to lose, and that is this concept that it depends on who wields the hammer. That's actually as important as the hammer, if not more so. And time and again, you see this in Chapter 3 especially, we talk about how it has to be the tribe that wields the federal hammer. Not because of supremacy, inverse supremacy of federal law or something, but because of a servant mentality that has to exist. It isn't just a trust responsibility. I think we talk a little bit more about the idea of a servant mentality that the federal government needs to have toward tribes. It's got to be based on respect. So, for example, to get to what Dorothy said about the FBI reporting, it is the case that it was not until, and we have this in Chapter 3, 2009, that the FBI even included tribal statistics in the Crime in America annual reports. And it was a protest that a few of us led, and it ended up being very ad hoc when it started. There was no requirement from Congress to do anything on it. They just finally, as a matter of good government, started to do it. But it's a very half-baked job, as you point out, because the PL 280 data, with just a few erratic exceptions, is not reported in any of that. And by the way, a lot of the federally recognized tribes are just completely missing. Some of the tribes are even missing. If you go through the list, as I did, that they're not even the right tribes. They have the wrong names. It's not clear what they're talking about. So, you know, that's not a servant mentality, because the presumption is the federal government owns the data. Our presumption of the report is the tribes own the data. The Native people, through their elected representatives, it's their data. It's not Washington's data. It's not the federal government's data. The same goes, and this is key, for testifying in tribal court. There's something called the TOUHEY regulations, T-O-U-H-E-Y regulations. If you're a U.S. attorney, one of your great power sources is that you get to decide if a federal agent testifies somewhere, and that includes in tribal court. We recommend a presumption that if a tribal judge says, hey, federal agent, come testify in court, the presumption needs to be that person's going to show up and be there, period. You have no idea the backlash out of all these recommendations that I hear about. How could I sell out the DOJ as I did by putting that recommendation in this report? I've heard more criticism about that from U.S. attorneys than practically anything else that we recommended. That people are outraged about that. They're not writing and speaking about it yet. They thought that was a crazy recommendation. How could a former U.S. attorney be involved in an effort? And the point is, again, we are there to, as a trustee, not to control, but to be a servant. The data is the tribes. The justice system is the tribes. If the justice system needs to serve local government, we provide support. Now, just to draw it to a close, there used to be an attitude in the state-federal relationship that was horrendous, where if you were on a task force, like a drug task force, that the feds funded, that they had to control everything. And the state players were just bit players, the locals were bit players. And I know some of the law enforcement officers in this room probably remember those days. That presumption has really been inverted, I think, in this country since the early 1980s to where we are today. You know, now pretty much the federal government, by and large, in many cases, is more of a servant, and the task forces tend to be more locally controlled. And even in a place like Denver, where I'm from, the gang task force that's funded by both FBI and DEA, it's always co-chaired by a local law enforcement leader in the FBI, but the FBI's attitude has been, or DEA, they take a back seat to what the locals want done. And they really have been pretty good about being servants. There's no reason why if we talk about a federal hammer that is one that is actually used at the discretion and the choice of the other sovereign, the tribe, that this can't work really, really well. But that's got to be a precondition. Thank you.
Thank you. That's outstanding. I think that's perfect.
Okay, we're gonna. All right, I'm getting the gong here.
I have one more.
Okay. Well, all right. Go ahead.
I promise. It's just
Angela. Can I have 5 of your minutes? You can take them away from
only,
Troy.
I'll give up 5 of my. Oh no, I won't. It's on juveniles. I won't give up anytime. So I just want to add one more thing. Part of the reason that we think the structure should change from the BIA to the DOJ is sort of identified in the simplest of things. Do you know that the BIA police are in charge of tribal courts in the BIA? That Director Cruzan is the person who's in charge of tribal courts. So if you can't get a fundamental structural thing correct, you can't implement that program correctly.
Well, I've been involved with Wolfchild v. U.S. for over 10 years now, and at this point the DOJ is my nemesis. And I wouldn't want them to represent me based on the performances I've seen in Court of Claims over the last 10 years. And you can read the published opinions. DOJ, it just gets hammered and hammered and hammered. And yet we're still in court, and they keep switching attorneys. I don't know, I think that's a different argument. It's a big argument, and I would have to be convinced that DOJ is the place to go to get the kind of collaboration that tribal attorneys need. Now, I had another question that I formed when the panel was talking, and you from Minnesota probably are aware of the 280 problems. There. It's a public law 280 state. And I also wish that we could get statistics. I'm an anthropologist, that happens to be my research area. My life research is there in Minnesota. Being a public law 280 state, of course, the county police, state police, city police, they all handle a lot of things except for just minor, what is it, $50 or 6 months in jail kind of business. And there have been heinous crimes committed. I mean, like a boy murdered the mother of his child and put her in the trunk. Luckily, it was very cold for a couple of months, because when they found her, she he was in this abandoned car in Minneapolis. There have been 2 people incarcerated for cannibalism, and I'm talking about the Minnesota Sioux. They're Prior Lake and Lower Sioux. Heinous crimes of dismemberment and all sorts of crimes like that. If you're going to have all tribes, you know, you said you underlined that 2 or 3 times. Someone said that.
I did.
Yeah. Then, I mean, there are some things that, you know, I think it's great to say we don't want them incarcerated, we don't need more cops, we want to rehabilitate and that sort of thing. But the reality is that in Indian country, there are those criminals who fall into that major crimes, into that rubric. And I think it would take special training and investigative, I mean, the kind of change that's going to take place. When you put that into a practical sense, to me it's mind-blowing.
All right, I think, Addie, can you make your comment on the next panel?
No, but it's all right. Okay, I won't sacrifice my own panel.
All right, thank you.